All right, good morning. We're here for a deliberation of case number CBA 17-008. This has a long history, as you do recall. This case had been at the ALJ, to the Board of Appeals, to the Circuit Court, to the Court of Special Appeals, back to the ALJ, and here we are with it once again. Originally, there was a circuit court ruling that res judicata applied, and then that was overturned. But then the appellate court sent back two specific issues. The issue dealing with the historic nature of the Stemmers property, and also the analysis for the panhandle lots. That went back to the ALJ. The ALJ, rather than having a new evidentiary hearing, did some extreme gleaning of the prior opinion from Judge Beverungian, issued a new opinion approving the plan, which now has come to us. There was also a cross appeal from petitioners because there was a condition placed on the decision that basically caused a prohibition on further subdivision of the property. And that's where we are. So I guess there's sub issues, but there's three major issues. And the first being the issue of the analysis, whether there was unacceptable detrimental effects to the historic site, being the Stemmers property, the Stemmers house. In reminder, in the first hearing, the ALJ at the time believed that a change in the law basically excused him from considering such issues as a whole. That opinion also was adopted by the board, which the appellate courts found to be incorrect. So there was to be an analysis that was to be done by the finder of fact, the ALJ, as to that issue. During the arguments before us, I believe that the major problem that the protestants had with the ruling was that the county witness basically never specifically by words articulated that issue in finding of the different departments and through planning. The arguments of the petitioners were that it was inferred that the county agencies had done their duty and due diligence, and coupled with the fact that there had been ample amount of testimony from other witnesses that would give the ALJ the information to make a decision. Before I go further on that, an argument that is clear is made by the petitioner. Just to frame this, we are here on a record appeal. We're very limited in our review in that we are not deciding the facts of the matter. We are basically making sure that the ALJ at least had sufficient evidence to rule in the fashion that he did. So there's that. The petitioner, in their memorandum to this board, went as far as to provide us with lists of excerpts from different witnesses, which they felt to be sufficient for the ALJ to make the decision and to approve the development plan after considering the charge of the appellate courts. So that's just the framing there. Before I go any further, because I usually talk too much, I am going to consult my colleagues to see, just to keep it focused. Let's start just on the historic issue. How about that? Can we start on that to see what we think about the protestants' argument that it was not sufficiently addressed, or also the sub issue that the ALJ got the presumption wrong meaning that since the county never provided any evidence, there was no presumption. And if he's making a decision on a presumption and not on the weight of the evidence, then that would be incorrect. So I'll throw that out there too for good fun to speak about. So anybody want to talk about that first issue?
I'm satisfied that, at least as to the first prong, that either way you address it, that there's sufficient evidence presented below and that there's not a basis to reverse or overrule the ALJ on his finding as to whether the proposed development has an unacceptable impact on the Caves Valley National Register Historic District.
All right.
And it was presented in the oral argument before us, and it's cited in the petitioner's memorandum, and so I don't see the need to read it or regurgitate it.
All right. I appreciate your brevity, Mr. Sampson. Ms. Bernardi.
I mean, that was a tougher one for me. I had to go through those, just the whole, analysis of that, but I did reach the same conclusion. I believe the ALJ gave lots of consideration for that, even if the representatives from the county didn't use specific words. The entire concept was considered and well reasoned by the ALJ.
All right, but I do join in that thought, and I went back and read several times actually the ALJ's actually order on remand, and also read the appellate opinion again as well. And I was looking at the way the ALJ made certain statements. At times he's talking about the presumption and stuff for county witnesses, which is language that is often used in the Elm Street analysis. I didn't see that he specifically used it as to this issue for the unacceptable impacts. But I did see that he said that the county witnesses and also the other witnesses from that were not county employees also offered evidence. As we sit as the board in a record appeal, we're only looking that there is sufficient evidence for the decision to be made. I think it is obvious from what the petitioners gleaned in their memorandum. There is quite enough for them to hang their hat on. So I agree with you too. So let's move on to the proposed panhandle lots and whether they meet the requirements of 32-409. This was an interesting one because, there was evidence on the record they went back and looked at, and I don't know if it was a problem of it not being clearly articulated by an ALJ and then again by this board, but it was required that the specific findings were to be made and for them to be articulated. And Mr. Sampson, to take a page from your book, sir, I'm not going to go through all those factors again, but it appears to me that the evidence that was gleaned by the ALJ, it is there. So even if there was great evidence to the contrary, it's not our job to decide which one wins the day. That is up to the ALJ. And the ALJ laid out the reasons of why he thinks it meets the requirements. And we are bound by saying, as long as there's evidence on the record to support it, and I think that there is.
Yeah,
And this one was oh, go ahead, Mr. Sampson.
No, I'm sorry. Pardon me. I just went the same batting order. I apologize. Go ahead, please.
No, I was just going to say that this one was less difficult for me. So I agree with you, Mr. Chair.
Mr. Sampson, sir.
I don't have anything to add. I appreciate how you remind for whomever's viewing the standard that we have before us. We're not to substitute our judgment on the facts. We're not to go back and pretend that this is a de novo hearing before us and we get to evaluate the witnesses and the evidence. It's there. We just have to determine that it was sufficient to meet the standard, and it does.
All right, well, wasting no time, we're moving on to the cross appeal. This issue here, this requires, maybe it shouldn't, but it requires some thought from me. First, I will say that it is, in my opinion, not that my opinion matters terribly, a really poorly written statute as to when one can put a condition on their decision. As Mr. McCann points out, the first several factors that are listed could easily be argued to be applicable to this development. What is very confusing to me is the last one, which deals with the removing of, I guess, density units or buildable lots, things of that sort. I'm flipping through my notes so I can read it.
At the 20%.
Yes. So, and it says and so the and part is interesting because I guess that, I mean, most of the time we're not dealing with, not most of the time, but often we're not dealing with a plan that falls into those zones. So the DR 545, 510. So the why it's there is just absolutely confusing. There's arguments, and there was an old board opinion, and I'm not completely swayed about it either, that try to argue that, since it just says DR, that means it can't be RC. That could one way to look at it. Or you could look at it to say it could be RC or anything else all the time, but you only have specific parameters when you're in the DR 55, 10.5, and 16. So that doesn't seem to make much sense to me either. I mean, basically, when I'm looking at this, it's basically saying you're allowed to reduce in these other developments plans in the DR, but you can't be done by more than 20%. Something this is what bothers me, and then I'll turn it over to you folks to tell me about it here. If you look at it says, in quotes, not reduced by more than 20% of the number of dwelling units proposed by a residential development plan. So it says proposed by a residential development plan. And what that means to me is that you're reducing dwelling units in a plan.
Right.
Meaning, like, I have a high density, like, housing development or something in a more residential zone. And I've said, yeah, you can have that, but I'm going to cut off these 10 houses here or those 10 houses there. This tells me I'm allowed to do that if I'm in a DR. That's what it's telling me. The language of in a development plan leads me to believe that it's a plan that's before the finder of fact at that time. I'm not convinced this encompasses the permission for the ALJ, or again, this board, to talk about future stuff. To me, I'm thinking about, isn't that another case for the future? Aren't we deciding another case? That's my question. So if you're deciding another case, how are you deciding a future case without hearing the specific merits of that future case? So neither the petitioners or the protestants brought that up, but that's something that's always bothered me in these situations. In making a blanket statement, you can't do any more of this or that. I don't know is that a power that anyone has short of someone bringing a new petition to do this or that. So that's my question for you two. And maybe I've opened a can of worms I don't want to, but that's something that I'm concerned about. Any thoughts?
I agree in thinking that it requires a specific residential plan to be before the ALJ in order to apply a reduction or a consideration of the reduction by more than 20%. What I'm not sure I understand, because I'm simple. Beyond that, and maybe we don't need to address it, but if this is an RC zone and this particular section is specific to the DR zone, I know you talked about this, but I'm not sure I absorbed it. Does it even apply at all? And to step back even further, the argument here is that the ALJ imposed this condition of no additional units in the future. The plan is not before him. The petitioners are saying that's illegal. He cannot do that. And the section that we're looking at, as you point out, that has the conjunctive, is talking about conditions imposed by the hearing officer. And it says in approving a development plan, the hearing officer may impose any conditions if a condition, and then it's 1, 2, 3, and 4 does not reduce by more than 20%. And what I'm struggling with, I don't even know that it matters, but he's actually not doing that. What he's prohibited from doing, he's not doing. He's not reducing the density by 20%. It's not before him. There's nothing to reduce. I know I'm not speaking very articulate, but I'm not even sure that this discussion applies. But let me ask where I was wrestling. If it's specific to DR and we're in an RC, why are we even discussing it at all?
I guess the converse argument would be that it's assumed that you can do it everywhere else but RC, but DR.
Okay.
That the argument would be that they put that in there because you could do it anywhere but there.
Okay.
I'm not saying that that's correct, but I think that's
Yeah.
the problematic nature of it. But I think something that hasn't been addressed, and you hit on it again, there is in a plan, when you have dwelling units in a plan, that is present tense. That's what we're looking at. And why that's important, because you're making factual determinations based on evidence that are unique to what has been put forth as to that plan. So it's very present tense language. You're dealing with something that's there. And in other cases where we see this issue being done is when you're actually, trying to remove something that's in a plan. This is not in a plan. This is not a removal in the plan. This is looking down the road. I believe that the reason that it's done is noble and also in keeping with the historic part of the consideration. Because my first thought was the appellate court gave very specific instructions of what they're supposed to deal with. And my first thought is this beyond the purview of the remand? But then, looking at it in intellectual honesty, that condition is tied to one of the issues of the remand. So I gave up that pursuit. But looking back at it, the language is very present tense to me, if that makes sense, meaning that it's talking about something that's being reviewed, not to get constitutionally crazy or something, but the constitutional parameters of reducing someone's ability for development that's allowed by law without hearing as to those specific issues is something that seems untidy to me. So, and what made me feel uncomfortable is that no, it wasn't brought up in our arguments, but that's something that's always bothered me about it. And in all honesty, I've seen it done in certain decisions before, and it hasn't been appealed as to, any type of decision as to it. But that's where I am with it. I don't even know what to call it, other than I believe it's beyond the ability of the ALJ based on that statute of what is permissible for a condition. I don't think it's a condition. It goes far beyond a condition. It's a prohibition. It's not a
Yeah.
condition. It's a prohibition.
Yeah, in a sense, and I'm wading into waters that are further over my head than where I already am struggling to stay afloat. But it would be the due process argument. And
Yeah.
it's if at some future date this landowner wants to submit a plan to increase the density or number of units, then the proper process must be followed, and someone then will consider the facts and the law at that time and make that decision. But I don't think that the ALJ or this board can go that far now uh, for the reasons you've more clearly articulated, but it's just not properly before the ALJ or the board, and either it's an advisory opinion, and I don't think these labels matter, or it's just an unconstitutional reach to prohibit development without due process of knowing what even would be proposed, because nothing is before the ALJ beyond what he considered and what we are considering on appeal. So it's a long way of saying I would grant the cross appeal, or not granted. I would I would find that the ALJ was improper here, and we need to reverse that decision.
Ms. Bernardi?
I was only going to add, I wanted to thank you for going through that constitutional explanation, because I was struggling with how or why did the ALJ consider the additional condition. By you sharing that you believe it may have been the ALJ's intent to address that one piece of the remand that was directed by the court helps with that explanation. But in doing that, I agree that these broader constitutional issues have now come into play, and I agree that they are beyond the ALJ and therefore our scope for this proceeding, and will agree with both of you regarding the cross appeal.
All right, thank you very much. I thought of another issue we should at least discuss. And it was an interesting issue that Mr. McCann brought forth. Was he was also saying that there was an error on the part of the ALJ for considering basically the changes in current conditions on the ground and surrounding communities, or basically the golf course and things of that sort, external things to the decision about the unacceptable impacts to the site itself. And basically his argument was basically that's not really what you're supposed to look at. You're supposed to look about the site. Who cares what they're doing around it? And then, of course, the petitioners had a different thought about that. My thought on that is, as a finder of fact, the term unacceptable in itself requires one to establish in their thought process the baseline for acceptable. I know that sounds like we're in philosophy class or something, but isn't that true? I mean, in order for one to deem what would be unacceptable, you have to have some knowledge of what is acceptable. So that, to me, does make somewhat of a difference, and is not the end all be all of the discussion, but I think is germane to a fact finder to determine. And I do agree with the petitioner that I don't think it would be improper for that thought to cross one's mind. Interesting enough, I don't know what bearing it has, no bearing, but if you look back, the fact that res judicata didn't apply brought us to this fact, because there was some differences in the site itself since back when Commissioner Murphy had made his decision, that had changed things slightly. So that's why we're here in the first place, that there was some changes that allowed the reconsideration of this matter. But yeah, so I do agree with the petitioner's argument that it is germane. I don't know if that changes anyone's decision as to their prior decisions, but it's something that should be discussed just briefly if anyone wants to comment on that.
Yeah, comment. I think another way of saying what you're saying is context matters. And I don't think, though, that the presence of any particular development, other use in the area necessarily forces a conclusion one way or the other. Because if it did, then this concept, which I very much reject, that merely by getting the first, let's say, increase in density in a particular area now means that all future decisions can just point to that and say, well, we've done it once, now all other developments fair game. I don't think it forces that conclusion. And that would be very troubling. And I've actually, I've seen this argument in a number of cases. Well, there's a royal farm that's in the area, as if now that's the breach, and all further analysis is thrown out the window, and we just say, well, there's already been a royal farm, now we can develop as we want. And I'm going further than you did, but it's just something I've noticed in other matters, and I think it's important. But I do certainly think that the context matters and it needs to be considered, but I don't believe it forces a decision in favor or against merely by looking to what else is there. For all the other reasons that we've discussed here and that are supported by the record below, it doesn't change my opinion, how we're ruling on the issues that you've clearly identified and we've discussed.
And I think the protestants were concerned about the weight that was given to the fact that there was the development of the golf course, and that's why they were making that argument. It doesn't change my opinion, but I agree that we should, in the decision, discuss that the fact of previous development doesn't then foretell any future determinations. So I do think it's relevant for us to address it in the opinion.
All right. Is there any other housekeeping matters as to these issues that need further fleshing out in your opinion, or are we finished?
I have nothing else to add. You've done an outstanding job as usual, chairing both the hearings and the deliberations that you run, and I appreciate your guidance here and your experience and your preparation and your professionalism in allowing us to contribute and reach consensus where it goes, and push back and sometimes try to convince you otherwise. I think these deliberations are very good. And again, for the purpose of anybody watching, we don't discuss any of this beforehand. We don't know what we're going to say. And sometimes, more is said and other times less is said. I don't know what anybody has as an expectation of the level of engagement that's required, but I do find on record appeals that sometimes it's less because we're bound by a record. So I'm adding a little more here just because I know other folks get on here and watch, and I don't know what their expectations are, but we have these hearings, and then we get these memoranda, and then we wrestle with it on our own. And it tends to be that someone takes a lead in sharing because we got to start somehow. And I've been on panels where that initial discussion and lean changes during the deliberation, and others it doesn't. And so I just appreciate how you handle these, Mr. Bell.
Well, thank you very much. I appreciate your contributions. And as you said, there's an incredible amount of reading that goes on before we sit down at these deliberations. So, and again, as is often seen, we are not the end all be all. there is appeals that go on, and when we are wrong, as we were, I am proud to say that I was one of the wrong guys on the original one when this came through the board the first time. Actually, I think the person who got the dissent and got it right was actually Mr. Evans, who's not on this panel, but I think it was Joe who actually got it right the first time. So, in any effect, so we're just humans trying to do the best that we can. And thank you all for your time. So we have basically in this fashion, we have affirmed the ruling of the ALJ as to the 2 limited points, and we have basically not affirmed or overturned the condition that was previously stated as part of the ALJ's opinion. And with that being said, I think we can conclude this hearing.
Thank you.
All right.